Hello, my wonderful law students. Welcome to Rich Educational Services. Today, I want to welcome you to another interesting and intriguing topic that we're about to discuss. We are about to look at planning for your estate. In the event that an individual does not plan for his or her estate, then the laws on intestacy will govern. So the topic for today is the law on intestacy. What does it mean to be in an intestate position or your estate falling on intestacy? What it simply means is that where a person does not dispose of his estate by way of will, then there's total intestacy. However, where a person has a will and fails to dispose of all of his estate, then partial intestacy will arise. In order for us to understand the law on intestacy, it is also important to appreciate some of the legal jargons that are associated with the law on intestacy. So one of the most familiar jargon that you will come across is the residuary estate. The residuary estate simply means that this is the beneficial interest of the real and personal estate of the intestate that were not disposed of and that he could have disposed of by will if he is of the full age and capacity, minus all the funeral expenses, his debts and his liabilities. For the purposes of the law on intestacy also, we would want to have an appreciation of who are the persons that qualify as a spouse under the Act. The persons that qualify as a spouse are those persons that are legally married to the intestate, in addition to a single man or woman living with the intestate as if they were a husband and wife 5 years immediately preceding the date of the intestate's death. In addition to these persons, a divorcee, a widower, and a widow can also qualify as a spouse. Let us move on to what are personal chattels. Personal chattels refer to furnitures, household effects, the motor vehicle. So this particular motor vehicle must not have been exclusively or principally been used in the operation of any business that the intestate had an interest in. Now, let us move on to what is this order of priority and what does the table of distribution dictate for all those persons that are found in the order of priority. As was indicated earlier, the specific act or legislation that deals with the order of priority is the Civil Procedure Rule. The Civil Procedure Rule basically lays down that these persons can, one, make an application in the court based on the order of priority. So those persons who are ranked first, second, third, and the list goes on can now put themselves in the position of an administrator and administer the estate of the intestate. So for the purposes of the Act, the surviving spouse will be the first person on the list to be in a position to make that application. So, as was indicated earlier, if the intestate died leaving a surviving spouse, so a person that he or she was married to, a person that was living with him 5 years immediately preceding the date of his death, then those persons would qualify as a spouse. So these are what the surviving spouse will be entitled to according to the order of priority and according to the table of distribution. So one, they'll be entitled to the personal chatters, absolutely. So if the intestate died leaving furniture, couch, sofa, you name it, then this person has a claim to all those furniture. If there's a motor vehicle that is usually operates as one that they use in personal leisure, right, then a claim can be made to that motor vehicle as well. In addition to that, 10,000 or 10% of the net value of the estate also belongs to the surviving spouse. In addition to this, if it takes some time for the amounts that was indicated in Part B, which is 10,000 or 10% of the net value of the estate to be paid over, then 10% interest can accrue on the amount until the sum is paid to the surviving spouse. Now, what happens in a circumstance where there are no issue? Issue here means children of the intestate. What will happen is that the surviving spouse will take all the residuary estate. So he or she is entitled to it, absolutely. If there is one child, then the surviving spouse is entitled to 2/3 of the residuary estate. If there is more than one child, the spouse is entitled to half of the residuary estate. If there is no issue and there is a parent or parents, then the surviving spouse is entitled to 2/3 of the residuary estate. Now, let us move on to the second group of persons in the order of priority. The second group of persons in the order of priority is the issue of the intestate. To be an issue, that particular person must have been a child of the intestate. So the issue must have survived the intestate for the purposes of the law on administration. So if there are issues, then what will happen is that, and there is no surviving spouse, what will happen is that those issues will take 100% or they're entitled to 100% of the residuary estate of the intestate. Now, if there is no surviving spouse and there are parents, the parents will not be entitled to any portion or be a beneficiary under the law on intestacy. Right? So let us move a little bit further. So if there are no children and there is a surviving spouse and parents, then as was indicated earlier, the surviving spouse would take 2/3 and the parents would take 1/3 of the residuary estate. The law does not stop here. The law makes further provision for those persons that are deemed to be relative. So relatives can also make an application that they can or should benefit from the intestate's residuary estate. So it specifies that brother and sister of the whole blood, as well as brother and sister of the half blood, can make an application and are entitled according to the table of distribution, in addition to grandparents. Also, uncles and aunts of the whole blood, uncles and aunts of the half blood, and as well as other relatives may make that application. Now, if there is no surviving spouse, no issue, there is no relative to make that particular claim or application, then all the residuary estate will go to the crown bona vacantia. But let us look closely at the Intestate, Estate and Property Charges Act. That act empowers children who are basically described in accordance to the act to be made for an application to be made on their behalf. So usually because of the injustices that arose, the Administrator General would be charged or empowered to make that application on behalf of the child. For the purposes of this act, a child is anyone who is 1, in the womb, 2, an accepted stepchild, a person who is under the age of 23 but over the age of 18, who is pursuing further academic discipline. In addition to that, any particular child who is considered to be disabled can be made an application on their behalf. Now, let us move on and look a little bit further on the Inheritance Act. The Inheritance Act basically states that persons who are considered dependents can also make an application or a claim to have a stake in the intestate's estate. So those persons that a reasonable provision was made for prior to the death of the intestate may make a claim. So these persons can include, but are not limited to, the parents of the intestate. In addition to this, the husband or wife of the intestate can also make an application that they have an interest in accordance to the act. In addition to this, any relative that would have been living with the intestate prior to his death may also make an application. What will the court look at when they are making consideration as to whether these dependents are entitled? They will look at the nature and the size of the estate. They will also look at the financial resources of the applicant. They will also look at the relationship between the applicant and the intestate. They will also look at the obligation of the intestate to other applicants in addition to this. These are not limited. The list is not exhaustive, as the Inheritance Act also makes further consideration whenever applications of this nature come before the court. In addition to this, once the court is satisfied that these persons qualify as dependents and one of the grounds or can be established, then what will happen is that they can make an order as to a lump sum, a periodic payment, as well as a transfer of property. Now, I hope you have learned something very, very important. In the absence of a will, the law on intestacy will govern. Even if there is a will, but some of your estate is not properly disposed of, then what will happen is that there will be partial intestacy. Those assets will fall in the residuary estate and will now be governed by the law on intestacy. So, while you're in a position, while you are mentally capable of making that will, then go ahead and make the will. In the absence of this, anybody can make a claim. Even a relative that you would have had some amount of disagreement with can make an application in the absence of those persons who are found in higher rank in the order of priority. Please remember to like and subscribe. See you next time. Goodbye.